Good afternoon, everyone. My name is David Jarzbeck. Like Alan said, I work in the Intellectual Property Department at Royse Law. And then I hope you can see my slide here. It's protecting intellectual property in China. I'm going to cover some of the basics. I think Paul is going to go a little bit more in depth about the various matters. How do we switch to the next slide? Do I have that? Just spacebar? Okay. That's not working. There we go. Okay, so the first thing that everyone needs to understand is the territorial nature of intellectual property registration. Registration of patents, trademarks, and copyrights only provide rights in the country for which they're registered. So in other words, if you have United States registered trademarks, that does not allow you protection in China. And then there's some quotes from the stopfakes.gov website, which is a website provided by the US government, and it essentially talks about that the United States government is not going to take action in protecting your intellectual property rights because it's considered a private property right. And so what you need is an attorney like us here at Royse Law and a multifaceted protection plan in order to protect your intellectual property. So the benefits of registering in China, it prevents goods manufactured in China from being seized for infringement. One of the common things that you may hear about is if you do not have a trademark registered in China, and you go to China and you start producing a product and there's a trademark on it, someone in China can register that trademark and then bring a trademark infringement process against you, an action against you, and prevent you from being able to distribute those goods in the United States or in China. It provides, allows Chinese customs to seize counterfeit goods, and it also protects your ability to expand in future value. So one of the concerns is that even if you're not necessarily producing in China now, and I think as Paul will discuss later, China is a first to file trademark country, so it is something that you want to do as soon as possible. Another major difference between China and the United States is when you're filing a trademark in the United States, you need to be showing use of the trademark, whereas China, you do not need to show use in order to file for a trademark registration. So if you go to China with a brand and you have a lot of time and money invested in that brand, and as you can see later in my slide, there's a possibility that somebody will squat on your trademark by filing it before you do, and then may try to hold you hostage and charge some kind of fee to get the trademark rights back. As I said before, China uses a first to file registration process. And one of the things when considering, and it's not too late to start the process to begin filing a trademark in China if you're considering going into business, is that there's the Chinese language trademark, the English term, and the pinyin name, and that'll kind of be explained a little bit later. The opportunity to file a trademark, you can either do that through the trademark office, and Paul may be able to assist with that, and then also us in the United States at Royse Law, we can file a trademark for you. And then there's something called the Madrid Protocol, which allows you to go ahead and expand those rights worldwide. And so a perfect example of this is Michael Jordan in Qiaodan Sports. What happened is an enterprising individual or business in China recognized the value of the Jordan brand and went ahead and registered the Jordan brand for Chinese trademarks. And you can see that on the left in the red, that is the Chinese version. On the right, that's the Nike Air Jordan symbol. And I think that I don't want to go into this too much because I think Paul can provide a little bit more in-depth answer, but I would say that this has been going on since roughly 2000, and recently, just this year, Qiaodan sued Nike for trademark infringement again. So the point here, I think, is that you can take a look and you can see this has happened for Pfizer as well with Viagra. A little bit of upfront costs in registering a trademark can go a long way in protecting long-term costs, because you don't want to necessarily be in an 18-year legal battle over a trademark in China, because that'll be significantly more expensive than spending a couple $1,000s up front that it costs to go ahead and file one. For patents, there's a number of ways that we can file a patent for you and then have patent protection in China. A lot of this is based around understanding that just because you have a patent in the United States does not mean you have a patent in China. And then also, one of the concerns here is when you go to this trade show is to make sure that you're not disclosing too much information. If you have patentable material, if you disclose that and make that public, there's an opportunity that A, your patent won't be granted because you've made that information available to the public. And even if your patent is granted, later at litigation, someone may go back, find information that you've released at a trade show, such as the upcoming event, and then determine that your patent's actually invalid. So be careful on what you're revealing. You don't want to reveal too much that's intellectual property, so that way it becomes in the public domain. Trade secrets. One of the things you have to consider is there's a lot of staff turnover. There's been a number of cases with this. There was an important semiconductor fuse case where an employee from a Japanese company went over to China and took the recipe for the fuses with him, and it ended up causing a bunch of problems. You want to have internal systems to protect trade secrets. One of those things is non-disclosure agreements with employees, making sure that you're closely monitoring employees who are accessing trade secrets, and then just monitoring where they go afterwards and who they're competing with. I think an important thing is here at Royse Law, we have a trade secret audit program where we help people go through and make sure that they have systems in place to protect themselves. U.S. trade secret law won't necessarily protect you in China, but kind of those fundamental elements that people are taking in order to protect their trade secrets is something that's applicable everywhere. So that's something that I would consider. Non-disclosure agreements. So the concern with U.S. non-disclosure agreements is there's multiple sources that say that that's not as reliable as having a non-disclosure, non-use, and non-circumvention agreement, because the concern isn't necessarily that a Chinese manufacturer or a Chinese entity is going to go ahead and share your information. It's more likely that they're going to take your information and use it with a subsidiary or affiliate and then produce and compete against you. So one way to attempt to prevent that is through non-disclosure, non-use, and non-circumvention agreements. And then finally, we have copyrights. Copyrights arise automatically for any work created inside or outside of China without requiring registration. That's because China is a signatory to the Berne Convention. But I think that this gives me a good opportunity to talk something overarching kind of theme, which maybe Paul can agree with, but a lot of people don't necessarily know that in the early 1800s, the United States was a notorious copyright infringer. And I think that when you look at developing countries like China or countries who have an interest in themselves to not protect intellectual property as strongly as is done in the United States, that there may be less level of intellectual property protection. So one thing that's important is even though the copyright arises automatically, you want to register copyright works with the Copyright Protection Center in China. You also want to register that in the United States. So the other part that I would say is just outside of any legal recourse, and I think the next slide is going to be some of the steps you can take if you've actually successfully registered all of your trademarks and your intellectual property. Make sure before providing any sensitive information that you're conducting due diligence of potential foreign partners. An important aspect of this is that you can find if somebody has maybe misappropriated information in the past, that'll be kind of a red flag and say that you should perhaps consider avoiding doing business with them. Strictly limit the availability of information at trade shows. There's a number of indications. There's a number of circumstances where people will provide information at a trade show, and because the production process in China is so quick in comparison to the United States, people can actually go ahead, take your idea, manufacture it, and bring it to market quicker than you would because you've disclosed that information. If anybody's interested, there's a really good Wired YouTube series on the production process in China and the reasons why you would want to compartmentalize that information, because like I said, once people get information about your idea, there's not a whole lot that's going to prevent them from being able to use that information and produce a product. And then finally, compartmentalize critical steps in the design and production process. So that may go to the idea that if you have one device or one idea and it really contains 3 or 4 important steps, that you want to compartmentalize those steps so that even if somebody misappropriates your intellectual property, that they won't have access to all the really important information. So strategically, those are some important things that can be done that don't cost the services of an attorney. And then finally, I would recommend that before anything is taken to China and provided, that at the very least there's trademark registration or intellectual property registration in the United States. That may not necessarily protect you from production and distribution through the rest of the world, but at the very least it'll help by preventing any type of import into the United States. So a lot of people aren't necessarily aware that the U.S. Customs and Border Protection has an e-recordation website, which allows entities to record copyrights, patents, and trademarks. And what happens, and the benefit of this, is that customs will actually be able to go ahead and seize any infringing material at the border and prevent it from being distributed to retailers. So as a best case scenario, even if someone's infringing, you don't have to worry about picking those up at swap marts or retailers. You can stop that at the point of entry. Additionally, it's important to register trademarks and other intellectual property in China. Because like I said before, what an individual can do is register the trademark, because China is a first to file system without needing to show any type of use. So if you're manufacturing, they can have Chinese customs seize your products. And then if you were the first one to register, you're going to avoid those additional costs of litigating that situation in court. You're not going to end up like Nike and Qiaodan, where you're in an 18-year legal battle. But what you can do is register with the General Administration of Customs in the People's Republic of China. All types of IP can be registered, and that's going to assist you from even an earlier start rather than the US border. It hopefully won't be able to leave China. And so that's the end of my presentation. I guess Paul is next, and then I think we're going to take questions at the very end. Mic off?
Yeah. Paul is muted.
Can I tell him that there's a text box to enter in? Okay, and then I guess we have Paul on mute. So Paul, if you could unmute yourself. And then also I want to let everyone know that there's a text box that you can enter in questions that'll allow us to answer your questions at the end of the presentation. I kind of went through that a little bit too quickly. No less questions.
So Paul, if you're speaking, we can't hear you. It's still silent. Is Paul
Hello,
muted?
Roger.
Okay, now I can hear you, Paul. Okay.
Sorry, I might lost a bit the signal here. That might because China government might got serious encryption software and banned the internet from moment to moment. Sorry that. All right. I might move on so everyone could hear me, right?
Yeah, Paul, I think you're good.
Yep, you're good.
Okay. Right. Sorry guys, I don't have any slides today, but in China we got a saying that if you got any information that comes a bit confidential or matters at some point, so don't show up the presentation. So today I would share a bit about my practical experiences to you, give you a feeling on how to protect your IP in China and how to enforce your IP from China. My presentation might chop into two parts, and probably those two parts is what I want you be aware in your mind. The first issue I wish you could understand is first to file, and second issue I wish you could bear in your mind is multi-faceted approach in setting up IP disputes, right? As a Chinese lawyer, one of the worst part of my job in China, when I practice law, is when a foreign company, today it's usually an American or European, many of them are Australian companies, they contact me after having essentially lost their IP to a Chinese company. Probably it's right their Chinese partner. In those situations, what we would do first, we would review the relevant contracts and the relevant IP. Usually in China, the IP is more related to trademark, copyright, patent, license, and so on. And we would review those IP registrations to determine whether or not they have a good chance to allege the IP infringer. And most of the times, especially the US clients, they would ask us to find out a good case, a sound case against the alleged IP infringer, and I will let them know, sorry, in China, we are civil law countries. The case does not have binding effect in the court. Even you have a good case in your hand like a few years ago in district court, it does not mean another court need to follow that case. Then what we do in practice is like all the court need to following the regulations from the Supreme Court, even the explanation of the Supreme Court. That's why we call civil law country. This is a bit like Germany, not like the US. Yeah. Then the overwhelming majority of the time, our clients do not, and it's no fine. Essentially, tell our client that sorry, you have lost your IP, and actually there's a little to nothing we can do, because you did not do what you need to do beforehand to protect IP from China. And basically, to be frank, many or I might need to say most Chinese manufacturers are no longer content just making products or foreign companies. They now want to make and sell their own products. This means you need to do various things to prevent Chinese manufacturers or your Chinese partners, especially like when they manufacture their products in Hangzhou or Shenzhen or Guangzhou, from register your trademark and your IP in China, then copy and sell your products worldwide. Yeah. That's why I come to my presentation and tell you the first issue is about first to file. We will move on to the details a bit, like the trademark. When I talked to the trademark, I remember one case I handled like a few days ago. One like not that famous US real estate company from LA, basically they runs business to help Chinese immigrations or young immigrations to buy houses in LA. And one day they realized the market is booming in LA. They wish like they could move to do business in China to set up their like window office in China. They ask me like what they should do first, and I'll tell them you need to do a trademark registration. And usually we would do a preliminary trademark check through the TMO, like trademark office system, and I would let them know whether you are successfully registered that trademark or not. But for that trademark they wish to register, like usually the whole process to register that trademark in China is 1 year. On the third month that you file, you've got like the notification from TMO office say, oh, we've successfully received your application. And on the 6 months since you file, you will get a rejection notice or like approved notice. This is like preliminary like stage that you've got a letter from TMO office. And from the 9th month, since you file, you will get second round like notification from TMO office. And eventually, like after 1 year, you finally got approval of your trademark. But for that case, for that real estate company case, we failed to get that trademark because someone from one of the biggest, what I might say, one of the biggest prohibited or conflicted like province, they do fake IP in China, which is very famous, called Henan province. One of the company from Henan province, they take the advantage to register that trademark that our US clients is not able to like get it as they want. So they get to me and ask me what to do. And I say, all right, so usually in China, the common practice is like you pay $50K US, 50K to buy that trademark. And do not talk to them and force them back communication with them. Otherwise, the Chinese would high up the price. Like, and the US clients come to me and say, could I like picture like picture them something like we could do cooperation on the trademark using, and I could support your business overseas, and you could still do your business and earn money in China. Well, let's do a cooperation something. And I said, no, Chinese will not think like that. One day they list up all the like trademarks on market. Oh, actually, we got a trademark market in China that like everyone could like log in the system, find it. The common price is there. If you want to get trademark, then go and drop down your price and left. You don't need to like force and back communication. Otherwise, they may like Chinese clients may Chinese people may understand. Oh, you take strong interest in getting that trademark. I will definitely high up the price. Then 50K for a big companies in the US, that's not a big deal, but 50K, that means something for startups companies. Then my clients head back to me and they say, could we like the same as the US, yeah? Could we revoke that trademark he registered, or could we invalidate that trademark? And I told them, sorry, that needs bunches of evidence in China. We need to prove that we actually use our trademark, the one we wish to register. Yeah? We actually use the evidence to show to the like judge and say we actually use that trademark in China at least 3 years. And on the other hand, we need to prove the evidence, tell the judge that the Chinese people, the Chinese registrant, they have not used their trademark in the market for the past 3 years at all. You know, the evidence threshold is really high, and I don't recommend the US clients doing this way. That's why I told them, could we like change a bit on the trademark? As like it's quite easy if you could change a picture or some of the wordings have distinguished meanings at some point, and then we file again to save money. And the client say, all right, so we put on the picture, and we like add a few more words after the trademark we wish to register. And I said, okay, but due to my experiences, it's better for you to put all the wordings as capital letters or non-capital letters. By this, yeah, it's like we could increase up or other possibilities on register. That's a practice in China. So the clients like doing the way I said, and we file it again, and we are still in process of awaiting the notification from TMO office. So this is a typical like trademark prohibited case in China. Like lots of Chinese, what can I say, entities, they ran a business in China by taking advantage of the registered trademarks in like from the US clients, Australian clients, and then like even European companies, and they sell it by second hand to earn money. Then, yeah, this is what happened in China. So every time we face those things, we need to bear in mind, we need to do something beforehand before we come to China and do the first to file trademark, as well as business names, patent designs, even copyright and software. So go back to the Qiaodan case. The Qiaodan case has done by actually, what can I say, is Royse Law Firm's lawyer. And what I want to let you understand is, if you want to win by the Qiaodan's case or alike, yeah, if you believe you got really famous or well-known trademark, and you got some like Chinese opponent who registered ahead, and you want to win that case. Okay, the secret one is you need to high up your case or lift up your case to Supreme Court. And this is the only way Qiaodan case win and they stage, because they lift up stage like step by step. They lift up the case from district court to city court, and they lift up from city court to provincial court. And finally, last year, they lifted up this case from provincial court to Supreme Court. And only the Supreme Court could, they could give a conclusion that a particular trademark is well known in China. Yeah, by those conclusions from Supreme Court, well, if your trademark is recognized as well known in China, you have the priority right, the right to priority, that you can destroy other components registration. But this is really hard. That's why I said you need to lift up the jurisdiction court. And in what way to lift up the jurisdiction court? That by many ways. For example, you could lift up the claim value. Yeah, so different courts, they manage different value cases. If you could lift up value, then the cases might move on level by level. And the second thing is you need to demonstrate on that this case might matters a lot about the foreign trading and Chinese trading that may has huge impact on the society, especially in the market where, for example, the Qiaodan sports here, in the market of sports shoes, you need evidence to show that to the judge. A third thing that I wish to say is the party who claimed that Qiaodan has no trademark rights in China is because he said Qiaodan is a river's name in Jordan, in Jordan. Sorry, that Chinese lawyer claimed Qiaodan's trademark is not distinguished at all. Everyone could use it. We Chinese could register the Qiaodan because that's a river's name, not like sports or sports star's name. That's why the district court, even the provincial court, agree with that because they believe that it makes sense at some point because they want to protect their local economy in China, especially Guangdong province and the Henan province here. Their IP protection in that places are really bad. Even the judge has no consideration of justice at some point. So that's a reason why the Qiaodan's lawyer they high up the value on that case, and they high up the value of the trademark disputes to the Supreme Court. And last year, Supreme Court in China, they give the conclusion, they give the final decision, say, sorry, the Chinese company, they priorited the Qiaodan's trademark, and they even taught Qiaodan's names right. So that's a whole case. By this case, I wish to say the local protection in China on IP rights is very bad in some provinces. Zhejiang, which is really good, and Hangzhou is really good, but Guangdong and the Henan province are really bad. That makes us to understand if you gonna manufacture your products in southern part of China, especially Guangdong province, yeah, because they got a cheap labor, you need to bear in mind, from day one that you put your manufacturing line in China, in a southern part of China, you need to protect your IP, not only by first to file registration, but you need think about a multi-faceted approach, including workplace security, employee contracts, commercial contracts, especially with SOEs, that stands for state-owned company. When you do business in China, especially for big deals, you definitely would come to a dialogue with the SOEs, and they got huge power, even they got monopoly rights. so you can't conflict with. That's why you need to very smartly chip in your IP protection clause in that template, not your contract template, but in that template, and better to enforce, protect your IP. Well, I might move on to the trademark issue. If a trademark use any words, it's very advisable to also register the Chinese language equivalent. So every time you wish to register your like English language, you need to bear in mind, oh, I have to register the Chinese language equivalent. Otherwise, someone would take advantage to register it. And one day you fall back and say, oh, Chinese only understand Chinese, then you've lost your IP totally. A sound mark could be registered as a trademark a few years ago, about three or 4 years ago. Business names. Business name must be reserved with a relevant local administration for industry and commerce in China before submission of application to set up your foreign investment enterprise. Business name must be in Chinese, and you can't. A few clients, US client, come to me and they say, could we chip in some English words in the Chinese names? And I say, no. Everything, even the filing documents in China, like the filing documents on trademark, patent, design, and copyright materials, all need to be in Chinese. Even the signing paper need to be in Chinese. One day you sign on an application, like you need to sign on the Chinese version, not the English version. That's what the government in China says. So, but however, it's like the business name in Chinese, like, will only give rise to the Chinese language business name within the particular administrative area, and trademark registration offer better like protection in this regard, and should therefore form part of any China investment strategy. And for the patent design, also first to file basis. This is more sensitive to many technical companies. Filing in another member country of the Paris Convention could give you 6 months priority like protection. For example, if you registered a patent or like a trademark in the US on 1st of January, and like in the coming months, like within 6 months, if you wish to move your business in China, then you want to register trademark and patent again, then the good way is like we would file the priority rights document to TMO office and patent China office and tell them you've already get your registration of trademark and patents in the US 6 months ago. As long as like within 6 months, you will get priority rights in China. That means on the day that you granted like trademark rights or patent rights, your successful registered date will still be on 1st of January, the same as US. So this is a good thing. This is a thing like US clients should strive for. One more thing we need to focus is like compulsory patent licenses. This is a bit sensitive in China, actually. The compulsory patent license may be granted in some instances, including in the event of national emergency. But the point is, like, the country in China has not like clearly identified what is national emergencies. That's why a few of the clients confused about. The national emergencies where the patent holders exercise of his patent rights is determined to constitute a monopoly, and the anti-competitive effects need to be eliminated or reduced, or where the patent holder fails to exploit or fully exploit its patent without any justifiable reason after the lapse of three years since the date of patent being granted. Actually, one of our clients encountered such issue. Like his manufacturer technology is like have patent 3 years ago, but like the local government, I mean the local SAIC, Administration for Industry and Commerce in China, compulsory like license to anyone in Guangdong province to use that patents for free, and that's ridiculous by at least from the point of view of U.S. clients, but that happens in China. And what we usually do, we first we would move on to talk to the local SAIC as well as the provincial management bureau. We will let them know, yeah, this is like illegal. You don't have any legal groundings about that. But definitely on the district level of SAIC in China, they don't care. That as long as we like high up the issue to the provincial level or city level and ask the city level bureau to issue a notification and stop that behavior to the district level SAIC. Well, but actually in that case, both the city level and the district level SAIC don't care about such infringement. And what we do, yeah, is like we file a litigation in the provincial court. Like actually we did not purposely want to win that case. We want to show our pressure towards that case, because for the governmental disputes, yeah, it's less than 2% success rate every year. So we understand that's really hard for us to succeed in that case from litigation point of view. So we just give them the pressure, and by lifting that disputes from like city level SAIC to the provincial level SAIC, and eventually we got a notification, like official notification from provincial SAIC to the district level, say they need to stop doing this like compulsory license, because this may seriously harmed the benefits from patents owner. Yeah. So, but overall, it's about 3 years time for us to do that. It's a long time and cost thing. That's why I said some foreign companies of clients, they need to value how sensitive is that technology. Yeah. Some of the clients choose not to register patents for sensitive technology in China because of the reasons above. Another thing is the copyright material. Copyright material may be registered with China National Copyright Administration. Registration may be very helpful for evidence of ownership rights in a copyright work, especially when we handle those cases to the court. Yeah. We will let the court understand we already filed a record in the copyright administration. Then that's a very good evidence. But this evidence does not constitute a precondition to copyright enforcement. You got your copyright from the first day you finish your work, but how could you approve it? That's why you need to do copyright record in copyright administration. Yeah. So and then we move on to software. Most of the U.S. clients are quite concerned about their software and how to like protect their software and collect evidence when they got infringement. Actually, the software could also be registered with the China National Copyright Administration. But what can I say? It requires a filing of source code, albeit with some code blacked out or removed. You could remove some sensitive information, but for sure you have to filing the source code. That's why a few of the clients, every time they listen to what I said in China like this, yeah, they would say, oh, I don't want to register myself in China due to the risk of leakage. then I could understand that. But what I can say is like, this is a great evidence when your IP got infringed. That's why you need to like use some technical point of view to albeit some code. If you think you are sensitive, then remove that code or remove a bit of the mark by technology. Domain names could also be registered in China on a first to file basis. Those all are first to file like basis that which you could bear into your mind. Due to the time limit, I think I might move a bit faster. Okay. The second issue, as I told you before, I wish all the US clients could understand we need to adopt a multifaceted approach. So when you do business in China, you want to protect IP, but everyone understand is IP is not only like a registration. Yeah, more importantly in China is about enforcement. How to enforcement your IP in practice. This is more important in registration. So the first thing is like workplace security. Yeah, maintaining system to control IP leakage from the workplace is very necessary. My advice is every document, like nearly all the documents that you public to, especially your Chinese partners when you set up joint venture company, you need to mark confidential information on the letterhead. And you need to mark that thing in Chinese. And this is very important because a few ridiculous cases we handled like years ago, like Chinese partners say they don't understand the word of confidential in the letterhead. That happens somehow, and local courts say, we only recognize Chinese words instead of the English words, and Chinese wording shall prevail. This is what the contract says. That's why they don't believe the U.S. clients like put safeguards on protection on the IP protection or confidential information. That's why we advise our clients put like both English and Chinese version of confidential information on every letter they issued or communicated with their Chinese partners. By this to enhance is like useful evidence in Chinese courts. Another issue is about encryption. The use of encryption products by a foreign incorporated entity or any of its Chinese branch, representative office, license office, or other business entity, or window office. Most like US clients might say it's window office. That does not have a PRC legal entity in China. It's subject to approval by the state encryption and administration. This is the point that most of US clients they're likely to miss because they believe the technology of encryption from the US is much better than the one that we have in China. But 2 years ago, the Chinese government set up a state encryption administration office. Yeah, and by this office, the government asked all the foreign legal entities to report the product that they use to encryption, and they need to report it like every 6 months in China. This is very strict actually. But if you fail to do that, like the SAIC Bureau and the State Encryption Administration could fine you. And even like according to the law in China, they even could give you 5 days like in prison. This is very serious, but that's what the law says. So I believe in the coming next years, like the encryption law in China might put into force quite like strictly. Yeah. And another thing is about employees. Employees, we all know we need to chip in the confidentiality obligations clause in the employees agreement. Yeah, this is the wide range of workplace information can be contractually protected as confidential information. Another issue I want to dress up in the employee agreement is about a non-compete clause. Post-termination non-compete clause may only be entered with senior management personnel or senior technical personnel or other like personnel with confidential obligations. Reasonable compensation is definitely required to be paid on a monthly basis during the post-termination non-compete period, and bear one number in your mind, 2 years. The term of a post-termination non-compete obligation cannot exceed 2 years. Some like US clients, they come to me and they say, I want to drop in like 5 years non-compete period. I said that's illegal, but you also can do that if you don't chip in those clauses in the employment contract. You like chip in those clauses in different nature of contracts with bunches of payment. That also works and recognized by the local arbitration commission. Now, why I say that's arbitration commission? Because all the labor disputes and cases need to be heard on the arbitration administration first. Then it could be moved on to the court. If you don't heard in the arbitration, then no way you could move on to the court. That's what the law said in China. Another thing is about IP assignment. Well, this always talked irrelevant with IP license actually. The ownership of IP created in the course of employment should be clearly assigned. Without such provision, it can be really difficult to enforce IP rights against a non-cooperative employee. So IP assignment need to be seriously put into contracts. Another interesting thing is like I always heard from US clients is product selection. Actually, I'm not expert in product selection, but it always takes much time for our clients to talk to me about those issues. They teach me how to think IP protection from this point. Like careful thoughts should be absolutely given as to which products to manufacture in China. For example, some foreign investors may prefer not to manufacture in China products that require new and sensitive technology in Henan province and the Guangdong province. Alternatively, the components require new and very sensitive technology may be imported into China as sealed units or integration like with the rest of the products. But it depends on the commercial valuation from inner side of your company. Commercial contracts, per the commercial contracts, I believe I could give you another case that we handled it before. What time is it? Oh, okay. Every time you do business, like with big deals in China, that I believe 19% of US clients would have negotiation with SOEs, Chinese state-owned companies. They are big, they are powerful, and but the point is, when you have the product ownership agreements or product co-development agreement with those SOEs, you would always find a template dropped from their side, from SOE side. Yeah. So you have to think every time when you get those contract templates, you need to think about it. There is one regulation in China. It says if the development work, this clause here, absent a formal writing agreement that deal with the development work, well, then the SOEs can claim rights to the development work, and it also can claim certain patent rights based on the development work on the incremental change, new work basis. Yeah, actually, China, like Germany, does not require very much of an incremental change to arrive a new patent, especially for design patents. It's everywhere, actually. So it's more like, in China, we got one type of patents named neutrality model. Some European countries got this. And in China, even our lawyers could call it junk patents, because you could quite easily register those patents by most SOEs call it development work, like they have a co-development work, and mainly like developed by the US side of the joint venture, yeah. But as is co-developed, so the Chinese SOEs might claim a right to register the development work, simply because there is no contract clause say, oh, any development work belongs to like US side, or portionally or partly, in what part, to what extent, on what duration belongs to the US side. There's no clause in that contract. That's why people get into disputes. And well, actually, the way to deal with this is to enter into like what can I say, the full content product development agreement that directly confronts this issue. In the situation where you are asserting the entire ownership of everything done with respect to your own products, such an agreement is not complex at all. If the Chinese side goal is to infringe on your product, they will be reluctant to sign the agreement. They will say, oh, we will not sign this like agreement at all, but we will do it, right? However, if they sign this agreement with a clause, as what I said, the protection is powerful. It's very powerful, because the IP law said in China, like the ownership of that development work belongs to the one who contractually agreed to one party. So the protection is very powerful, but only like against the parties that sign. What we would do is, like in this situation, like if you release your own information to anyone, you are liable for the breach, like without regard to your own fault. We can normally draft this like as a very specific but very short agreement. However, we can also just include this type of provision into any form of global agreement with those companies. Yeah. Key point is like, never do a deal with a company you believe intends to infringe you, and you are not looking for a lawsuit, are you? Drop into a lawsuit in China is terrible, actually. So we never recommend clients do that. As you know, like recovery from infringe carried out by a huge entity like that SOE will be really difficult. Yeah. So those are the cases I share with you. Probably the last point I wish to say is about think about like administrative enforcement action when you unavoidably have IP disputes in hand. Yeah. So why I see that? Because in practice, China is a governmental centralized country. So various governmental authorities have the huge power to take like governmental actions or administrative actions against the infringers, and those are powerful. So such actions are typically more efficient and actually cost a little bit of money than litigation. And the standard of proof are also much lower. Yeah. Publishing successful administrative enforcement actions can be like generate goodwill with the relevant Chinese government authorities, and may deter future infringers. This is also very important, where like most of the US clients don't understand. It's like definitely like we need to show goodwill with a local local SAIC in China. Why? Because as long as we show them goodwill or like tax value we conducted to them, then by this they would require lower evidence thresholds when we claim IP infringement, and they would use a governmental like authority to chip in that defective like manufacturer like factory to looking for evidence and give them punishment and give their benefits back to us. This is very efficient. A few cases that handle like those days, and it only take 3 or 4 days for the local SIC and even the tax bureau. They got like 3 or 4 days to destroy a prohibited or like infringement factory in China, and they got about 50k infringement like benefits back to us. This is very efficient, and most US clients believe is impossible, but it is possible in China. And by doing this, yeah, we need to understand what like government authorities we need to like set up good communication with. Yeah, the first like the authority is SAIC. SAIC stands for the Administration for Industry and Commerce. SAIC and its like SAIC branches, especially the branches in your company districts. That's very helpful to set up a good communication dialogue. SAIC and the local SAIC have a reputation for efficient trademark enforcement action, including investigations and wreaths. The SAIC can also handle disputes relating to business names, registered trademarks, passing off activities, and trade secrets. Definitely, they are very efficient. I believe probably they are the best efficient authorities in China. Yeah, and the second one, what I can say is like the second ranking one is China Patent Office. They are efficient as well. The China Patent Office may support us or assist us with patent enforcement through investigations, evidence collection, and mediation and wreaths. The mediation becomes very important for you to understand when you have patent disputes in China. And every time we find out infringement disputes in Henan and Guangdong province, yeah, we all called up automatically by the local patent office there. It's not like we wish to go there. It's they ask us to go there, and they understand that we are moving to file a litigation on judicial point here, and the patent office on the same level, on the same government level of the local court, yeah, they understand this. They got this information, and they give us a phone call, and they say, "Hey, are you act on behalf of your clients in our district?" And I say, "Oh yeah, I am. So would you come and have a mediation in the patent office first?" And I say, "All right, we will go and do a mediation there." This is very common in China. When most of the US clients say, "Oh, why not just go and file a litigation or just call up for a high level like litigation?" And I say, no, this is a common practice, and you have to go for the mediation first. This will not seriously impact your later on litigation, but if you don't attend that mediation in the local district patent office, that means you are not showing a goodwill with a local authority. Then the local court in that area might trouble you a lot, especially in the in the part of evidence threshold. That's why we need definitely we need to go and attend that mediation. The rest of the debate is about national copyright administration. Actually, I don't believe the copyright administration has a huge power and efficient enforcement on such regard. But if your IP access, including a lot of like copyright, like especially on copyright issues, yeah, it's advisable for you to make a record in the administration. Yeah. The last thing is about some of US clients may think about how to seize their overseas access of infringers and how to do correspondent like correspondent cooperation in terms of block their goods transit. Then definitely we would come to the customs. Yeah, the custom authorities have the power to confiscate products that infringe trademarks, copyright, and patents. The better thing for them is like they are not efficient. They might usually take 3 to 6 months to respond to us. That's the practice in China. Probably another like another point we could think about is like go and ask for support from Chinese General Administration of Quality and Supervision Inspection and Quantonia. This other authority may be like involved if some of US clients' production quality and human health issues are in concern or in question. We could go for that. All right. Definitely. The last point I might move on a bit is litigation there. Why I choose the litigation is the last point is, yeah, definitely you might already know the answer due to the presentation I did before. Although administrative actions are typically preferred, but court action can be useful if injunctions are being sought or damages claimed. In addition, trademark owners have generally preferred to bring court actions against domain names registrations that private of trademarks. Yeah, and domain name disputes may be heard by a panel established by the China Internet Network Information Center. China set up like Internet Information Center like 2 years ago, purposely to handle those cases, and by the litigation phase, we could better to do like even criminal prosecution. Like, and I know in some European and Australia countries, IP infringement might cause serious criminal prosecution, but however, in China, this is really relatively rare. What can I say? Like, as long as in my past few years in practice, like IP protection law in China, I haven't found one case like someone like put into prison. No, this is because it can be very difficult to prove that the relevant financial thresholds for prosecution have been met. Overseas actions may be considered where many Chinese companies are keen to export and then products that infringe IP rights, and this could be blocked by, as what I said, customs in the port or destination, and such action require close cross-border coordination. But this action might take not efficiently, and due to my experience, it might take many months if you not like have a good communication with the local customs. Well, it might, this action might take nearly half a year and not completed yet. So we not recommend the customs support. Yeah. All right, thanks for your listening today. Those are the like basically all are my experiences and a few cases that are handled in the past few years in terms of how to protect IP in China. And my presentation may be not that like slides or PPTs, but those are the like cases or disputes that I wish all the US clients may understand more in terms of how to protect it beforehand. Thanks for your listening.
Okay, thank you very much, Paul. And just a reminder, if anyone is interested in a recording of this, we are happy to send you a recording. Just email Jesse. And then, Paul, I have two questions here for you. The first one is it possible to apply for a patent in China where there's prior art such as other similar patents in the United States?
There is a possibility about that. You need to file appeal to the TMO review office within 6 days when they give you a rejection letter or things like that. But one thing I should remind you is like it's only less than 5% successful rate every year in doing so. Yeah, and you need to prepare bunches of evidence in support you doing that.
Okay, and then the second question is what is the first step? Is it that someone should ask you to perform a preliminary study to see if a trademark is available, and that's in regards to filing a trademark in China?
Usually, we would do a preliminary trademark application check through our own system. We got own system authorized by the Chinese TMO office that all the trademark application agents and lawyers or legal office, we could do that. Through the preliminary check, we could give the advice to our clients and tell them, oh, if you want to register this mark, then you need to be aware there might be some other ones already take advantage in register the similar ones, then we would not recommend you to do so. And if they insist to do so, we will let them know. If we failed, then we might have a little chance to appeal, but we could revoke or invalid the prior registration if we found they haven't used it in the past 3 years after application at all. Then yeah, so basically we would do a preliminary trademark check for our clients. Then we would give the advice to our clients to say what trademark has like a higher possibility to get approved. Then we would let our clients understand registration trademark in China might take roughly 1 year to get approved. And on the 6th month, right in the middle of the time, you will get a first round notification and tell you that you are preliminary approved, and they're gonna put it on public for any others claim any right. And after another 6 months, yeah, it's 12th month, they will give you official registration license.
All right, thank you very much. And then in final summary, just want to say carefully consider the information you bring or disclose in China. The same reason to work in China, which is a quick and cheap production cycle, makes it easy to misappropriate intellectual property. And with that, that's the conclusion of our presentation. Thank you very much for listening.